Thanks for tuning in to Answers with Andrew. I'm coming to you again. My Ohio clientele, I'm filming these videos down on Sanibel Island at our family getaway. And these are short videos that are designed to equip folks and their families with just general good legal knowledge that it's good to understand these types of things to help plan and manage for the future. And so I'm trying to do these short videos in the areas that I focus my practice in, which is estate planning, estate and trust administration, corporate or business law, transactional law, and then commercial and residential real estate law. Today's topic for conversation is Ohio Advanced Directives, healthcare documents. What are they? Why would I want one over the other? What if I get both? Am I going to be okay? What do these things do? Do they conflict? How do they work? And so we have this general umbrella in Ohio that says this is advanced directives. You get under this umbrella two options. The first is a state of Ohio living will, and the other, or the alternative, is a state of Ohio healthcare power of attorney. Now, the first thing to understand with the state of Ohio living will is it only applies to people that are in two specific types of health-related situations. So the first is called a permanently unconscious state, right? And the second is a terminal condition. What's the difference? Permanently unconscious state is more brain-related, right? So two physicians have examined the patient and agreed that the patient has totally lost higher brain function and is unable to suffer or feel pain. That's the definition that the state legislature has come up with. This is not a case where someone just got knocked out for a short period of time. This is no, you lost it upstairs permanently. And the second is a terminal condition. Does not have to be brain related, right? This could be stage 4 cancer. This could be, just a MS. This could be a number of different health related diseases or viruses that what a doctor is saying is, look, this is going to end your life in a short period of time if something else doesn't kill you first, right? You are in a terminal condition. You're not coming back from this. And so what the living will does, and I'll spend just slightly longer on the living will than the healthcare power of attorney, is it allows you to speak to an attending physician. Who's that going to be? Probably not the person that you play in the golf league with every week, the physician that you know or that you go to church with that you say, well, that's my primary care doctor. That's not the person, right? This is somebody when you get wheeled in the middle of the night who's going to be calling the shots. And this document, if you have it on file or if a family member provides it to them, can speak to this person, this attending physician, and say, hey, I don't want life-sustaining treatment, right? I don't want artificially or technologically supplied nutrition or hydration. I don't want tube feedings. I don't want anything that would prolong my life if I'm in one of these two states. I just want comfort care pain, and I want to be allowed to die naturally. So that's your living will, right? Pretty narrow document, got to be in one of those two situations. Then you have the healthcare power of attorney, which alternatively appoints an agent and says, okay, who could this be? Who is this agent? Well, a lot of times if you're married, it's your spouse. Maybe it's somebody else, a sister, brother who is a nurse or a doctor, somebody who has some medical training, EMT, something like that. And this is somebody who you appoint to say, look, I want this person to speak to healthcare professionals for me and to help manage and make my healthcare decisions if I can't. If I'm in an incapacitated state and doctors say that I am no longer able to make or manage my own healthcare, this is who I want to transfer the power to. So this is a little form I've got just to wrap up that I've drawn, and I've got the umbrella of advanced directives in Ohio, and then instead of who, what, when, I've got what, who, when. And with the living will, as you can see, I'm giving power to the physician. And when I'm in a terminal condition or a permanently unconscious state versus a healthcare power of attorney, who am I giving my power to? I'm giving it to my agent. And when am I giving it to them? I'm giving it to them when I'm incapacitated. So the key difference with these documents is not just when they're used, but also who is getting the power. And then one question I'm often asked is, what happens if I have both? Well, what will happen is the living will under Ohio law will actually trump the healthcare power of attorney in the event that the patient is in a permanently unconscious state or a terminal condition, and there is a dispute going on between the attending physician and family. So not what some people would want to happen. A lot of people would say, no, I want my spouse to have, the final say, or et cetera, et cetera. So good to understand these documents. This video has been slightly longer than I wanted, but thanks so much for tuning in.